A pleasant day to each and everyone, especially to you, Mom. This is Marimar Oclida, and I'm going to report now the chapter 13, which is entitled Labor Law, and the subject Legal Aspects in Tourism and Hospitality. So this is our learning objectives. First is to enumerate the classification of employees, their benefits, privileges, and policies affecting them. Second, identify some best practices in handling human resources in tourism establishments. And last is to explain the rights of workers employed in tourism establishments. The tourism industry, with its labor-intensive nature, is prone to many labor issues. Hence, labor law plays a vital role in the efficient operation of the various business enterprises related to tourism. So, this chapter deals with important provisions governing labor laws as well as the benefits, privileges, and policies affecting employees. So, let's start with the constitutional provisions on labor. On the Section 3, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. In the Section 14, the state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. In the Section 15, the state shall respect the role of independent people's organizations to enable the people to pursue and protect within the democratic framework their legitimate and collective interest and aspirations through peaceful and lawful means. While in the Section 16, the right of the people and their organizations to effectively and reasonably participate at all levels of social, political, and economic decision, adequate consultation mechanisms. So the constitutional protection of labor rights, including the right to strike and a living wage. It emphasizes shared responsibility between workers and employers, promoting worker participation in decision-making processes. It also mentions the right of labor to adjust share in the fruits of production, which includes not just basic salaries but also profit sharing. Additionally, it highlights the state's role in protecting working women's rights to safe conditions and opportunities for their full potential. Moving forward, we have the classification of employees. So, employees of a company may be classified as follows: the regular employees, casual employees, seasonal employees, project employees, probationary employees, employees for a fixed term overseas Filipino workers, and the special workers like the apprentices, learners, and handicapped workers. So the regular employees is the employees who are deemed regular, those who have been engaged to perform activities which are usually necessary or desirable in the usual trade or business of the employer. While a regular employee is also someone who is employed by an organization on a long-term basis, typically without a predetermined end date. They are usually hired based on a permanent contract or company policy which establishes their ongoing employment relationship with the organization. So regular employees are entitled to various benefits such as health insurance, retirement plans, paid time off, and other perks provided by the employer. While casual employees are those whose employment is neither regular, project, nor seasonal as defined under Article 280 of the Labor Code. So Article 280 of the Labor Code is the primary standard that determines regular employment is the reasonable connection between the particular activity performed by the employee and the usual business or trade of the employer. The emphasis is on the necessity or desirability of the employee's activity. So, casual employees, again, are engaged for a specific job or service that is incidental to the employer's business for a definite period disclosed at the time of hiring. After 1 year of service, they become regular employees for that specific activity. And seasonal employees are those whose work or services is seasonal in nature and the employment is for the duration of the season. So regular seasonal employees are those called to work from time to time. So seasonal employees is They are employed for work or services that are seasonal in nature and last for the duration of the season. Regular seasonal employees are temporarily laid off during the off-season but remain employed and are re-employed when needed during the peak season. Next is the project employees. A project employee is one whose employment has been fixed for a specific project or undertaking the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or services to be performed is seasonal in nature and the employment is for the duration of the season. So their employment is fixed for a specific project or undertaking with a predetermined completion or termination. They are engaged for the duration of projects, and their status depends on whether the project scope and duration were specified at the time of hiring. Next is the probationary employees. A probationary employee is one who is on trial by an employer, during which the employer determines whether or not he is qualified for permanent employment. Probationary employment shall not exceed 6 months from the date the employees started working. And employees for a fixed term are employees covered in employment contracts providing for term employment or fixed period employment, while overseas Filipino workers, also referred as migrant worker. Overseas Filipino workers refers to a person who is to be engaged or has been engaged on a remunerated activity in a state of which he or she is not a legal resident. A person to be engaged in a remunerated activity refers to an applicant worker who has been promised or assured employment overseas and acting on such promise or assurance sustains damage and or injury. And special workers like the apprentices. An apprentice is a worker who is covered by a written apprenticeship agreement with an individual employer or any of the recognized entities. It is a person undergoing training for an approved apprenticeable occupation during an established period assured by an apprenticeship agreement. And learners are persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable and which may be learned through practical training on the job in a relatively short period of time, which shall not exceed 3 months. And lastly is the handicapped workers are those whose earning capacity is impaired by age or physical or mental deficiency or injury. So that's all for the classifications of employees. Let's move on to the benefits, privileges, policies affecting employees. And when it comes to minimum wage, we have the Republic Act number 6727 gives regional tripartite and productivity boards the authority to determine minimum wage rates. Minimum wages are not just about setting a floor wage but also promoting productivity improvements and gain sharing measures for workers' decent living standards. And in terms of collective bargaining involves negotiating agreements between employers and employees represented by labor unions on wages, working hours, grievances, and the like, resulting in a collective bargaining agreement. So the parties must have majority representation, initiate bargaining in good faith, and observe legal procedures. Failure to do so can lead to unfair labor practices, strikes, or lockouts. So Labor Management Councils, or the LMC, in which the employees, whether unionized or not, have the right to present grievances to their employer. LMCs, promoted by the Department of Labor and Employment, serve as communication forums for management and employees to address concerns and prevent or resolve disputes. So LMCs require elected employee representatives to maintain integrity and effectiveness, potentially reducing the need for labor unions in some cases. So let's tackle also the maternity and paternity leaves. So maternity leave, according to Republic Act 8282, Female members who have paid at least 3 monthly contributions in the 12-month period before childbirth or miscarriage are entitled to 60 days of maternity leave, 78 days for cesarean delivery, with 100% of their average daily salary credit. Employers must advance the full payment within 30 days of the leave application, and the SSS reimburses the employer. So maternity benefits are provided for the first 4 deliveries or miscarriages. And paternity leave on the Republic Act 8187, married male employees are entitled to 7 days of paternity leave with full pay for the first 4 deliveries of their legitimate spouses with whom they are cohabiting. Conditions include being employed at the time of delivery, cohabiting with the spouse, applying for paternity leave according to the rules, and the spouse giving birth or suffering a miscarriage. So, a Solo Parents Welfare Act, Republic Act 8972, solo parent employees who have served for at least 1 year are entitled to parental leave of up to 7 days every year, in addition to existing leave privileges. This law supports solo parents by providing them with leave benefits to attend to their parental responsibilities. So, in union rights, strikes, and lockouts, legitimate labor organization, or the LLO, can sue on behalf of members for money claims and must be certified as an exclusive bargaining agent through a certification election for collective bargaining purposes. A strike is a temporary work stoppage due to a labor or industrial disputes, while lockout, it is a temporary refusal by the employer to provide work due to a labor or industrial dispute. And labor dispute involves controversies regarding terms or conditions of employment or association in negotiating terms regardless of employer-employee relations. And next is service charges. Service charges are applicable to certain establishments like hotels, restaurants, and other listed. These establishments must distribute all service charges collected, with 85% going to covered employees and 15% to management. The employees' share is divided equally among them, while the management's portion covers losses, breakages, and may be distributed to managerial employees as decided by management. So, in employment contract, an employment contract is an agreement where an employee agrees to provide work to an employer in exchange for compensation. It is governed by the Labor Code, Civil Code, and other laws, ensuring the terms are lawful in line with public interest, morals, and social justice. While legally consensual, written contracts are common in industries like tourism to clarify terms, especially for probationary, project-based, casual, and fixed-term employment. Clear communication and understanding in contracts promote knowledge, understanding, and acceptance among employees. So, in death benefits, it is provided under the Social Security Law and Employees' Compensation Fund, while health benefits is provided under the Social Security Law or the sickness benefits, and in PhilHealth, work-related sickness covered under Employees' Compensation Fund. In terms of drug testing, it is mandated by Republic Act number 9165 for workplace risk reduction. Failure in testing can lead to termination. In terms of retirement age and benefits governed by law or collective bargaining agreements. So in uniform policies, it required in certain tourism establishments for accreditation. So the SSS, the PhilHealth, Employees Compensation Commission, and Pag-ibig is mandatory coverage for private sector employees. Various benefits including housing, medical, and retirement. So in the termination of employment, security of tenure protected by law. Just causes for termination include misconduct, neglect, fraud, and crime. Due process required, including written notice and hearing. So, Next is the laws against discrimination. The law against discrimination with respect to labor are as follows. The Republic Act number 7277, as recalled as the Magna Carta for Disabled Persons, prohibits discrimination against disabled workers, including limiting opportunities and equal compensation and unfair treatment in promotions. Second is the Republic Act number 6725, strengthens the prohibition and discrimination against women in terms of compensation and promotion opportunities. And third is the Presidential Decree 966, criminalizes violations of the International Convention on the Elimination of All Forms. So, in the employment protection for women, women are protected with safe and healthful working conditions, considering their maternal functions and providing facilities for their welfare. Prohibitions include employment between midnight and 6 o'clock in the morning, except for specific health and welfare services or tasks requiring women's dexterity. Employers must provide facilities like seats, separate toilet rooms, lavatories, dressing rooms, and nurseries for women employees. Employers cannot impose conditions like not getting married or consider marriage as resignation, separation, or discharge. It's illegal to terminate a woman employee due to pregnancy or while on pregnancy-related leave. So next, let us tackle the sexual harassments in the workplace on the Republic Act 7877. So sexual harassment is committed by anyone with authority, influence, or moral ascendancy over another in a work environment, demanding, requesting, or requiring any sexual favor, regardless of acceptance. So this law aims to prevent and penalize sexual harassments, ensuring a safe and respectful workplace environment for all employees. And that's all for the chapter 13. I hope you have learned something. Thank you for listening.